Hi guys, it's Jacob Blizzard. I'm a board certified criminal law and criminal appeal specialist attorney. I practice in Texas, and today I want to talk to you guys about the writ of habeas corpus process when you're writing a writ of habeas corpus, the considerations that you need to think about when writing your writ application and the brief. So, the thing to know about the writ application and the brief is the first person to see that is going to be the trial court. The trial court judge gets the first look at that, and they're going to make a determination right off the bat whether or not there are unresolved issues which the court needs to make factual determinations in order for the courts to decide the case. And so you need to make those facts obvious. You need to make them facts that are outside of the record, point out that these are facts outside of the record, because that's what writs are about. It's about writing about facts outside of the record. So you write about these facts that are outside the record. You talk about how your trial counsel was ineffective for whatever reason, or due process violation for whatever reason. Talk about those facts that have not previously been discussed. Don't just go over your trial transcript. Don't go over the records. You can certainly incorporate the records, and you can incorporate references in your trial as they pertain to this new information that you have conveyed. But you want new relevant information put in that trial, application, so that you can convince the trial court that there are things that need to be resolved. The other thing that you need to understand is the power of the trial court's findings. Okay. When you file an application, that trial court is ultimately going to make some findings in the case about the facts and about the law. Now, neither of those are actually binding on the Court of Criminal Appeals. The Court of Criminal Appeals can make its own decision independent of what the trial court does. But the Court of Criminal Appeals gives a lot of preference or credibility to what the trial court finds in terms of facts. That the trial court was there, they observed the demeanor of witnesses, they were there for the trial, they know the parties involved, they know all these things. And so they're going to defer to the trial court for facts. So it's your job primarily to influence the trial court judge. And you may think, man, that's very difficult because he presided over my trial and he sentenced me to however many years, or he let the jury sentence me, or he ruled against me on objections, or whatever it may be. Well, you know, that's the way that it is. You have to approach this idea that you need to influence that trial court judge. Now, if you're just convinced and you have actual evidence that this trial court is biased against you, you can ask that he be recused from your case, and you want to file that motion as soon as you file the application, so that a different trial court judge could be appointed to hear your case. However, if you don't have that evidence, don't do that, because you're just going to aggravate the trial court judge. And the other thing is trial court judges at heart are trying to do the right thing. They're trying to make rulings on objections. They're trying to make rulings on the law. That's what they should be doing. Okay, not all judges do it all of the time, but that is the purpose of a judge, is to rule on the facts as they are presented with applying the correct law. And so you need to put facts in front of the judge that persuade the judge and makes him or her understand that there is something about your case that is not right, that you did not get a fair trial because your trial counsel was inept, or there was some due process violation, or the prosecutor withheld evidence. And you need to put that at the forefront of your situation. The facts are the most important thing. And then it is important to talk about the law, because trial courts do deal with a lot of trial court issues, evidence, law, objections, but they don't get into that much appellate work because they're not appellate lawyers or judges. They work in the trial court. And so you need to point out that law primarily for their sake. Give them examples of other cases where the Court of Criminal Appeals or some other appellate court has determined that this was ineffective assistance of counsel, this similar example of another case. But you want to point out the law and show the judge why the law applies to your facts, and those facts being the most important thing. Remember, this is about persuading judges. It's not about saying things from your heart, from your emotions, and I know that is difficult, especially if you're doing this on your own pro se, for you to write your own application and not do it with the emotion that you feel in your case. But you have to step back the best you can and write it from an objective point of view. And you will earn credibility in the judge's eyes when you do that. Write to persuade the trial court judge. Facts, law, and then the Court of Criminal Appeals is going to give a lot of credence to that trial court's order. You want that trial court to be ordering that you should be entitled to relief, and so you want to present those facts as well as possible to him or her. Thanks for watching, guys. That's all I have this time. We'll see you next time. Thanks.